Good morning and welcome to the first of our weekly Meet the Team Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Can I start by saying how delighted we are that so many people have signed up to view the session today, and also the amount of questions that we've received from you has been phenomenal, so thanks very much for that. Very quickly from me, these sessions have come about due to the employment team here at Sintons having been inundated with COVID-19 and furlough questions following the introduction of the coronavirus job retention scheme and the ever-changing government guidance. The team has also been given some thought as to what work may look like following the relaxation of the current restrictions. So in order to give you an opportunity to share in some of that wisdom, the team have opened themselves up to these Q&A sessions, which are going to last until the end of May. And during the sessions, members of the employment team are going to answer 3 questions, either COVID-19 related or not, that you either haven't quite got to the bottom of or that your employees persistently ask you, We are actually going to be answering 4 questions today, so I have totally contradicted myself on the 3, but usually it will be 3. Okay, our speakers today, I just move the slides on, our partner and Head of Employment, Keith Land, alongside Associate Ailsa Hobson. So without any further ado, I'm going to pass you straight over to Ailsa to kick proceedings off. Ailsa, good morning and over to you.
Thanks, David, and good morning, everyone. So I'm going to kick off with the first question, which relates to the effects of taking statutory leave during or before a period of furlough. So I've included sickness into this question because, like some of the periods of absence or leave, this has a statutory payment attached to it, so SSP. So I'll start with that one and then I'll move on to maternity and paternity leave. So originally the guidance on sick pay said that if an employee is sick, then they cannot be furloughed. For short-term absences, this meant that once fit, employees could be furloughed, but for long-term absences, unless they miraculously recovered, they would remain on sick leave and could not be furloughed. But on 9th of April, the guidance changed and ultimately seemed to give the employees the choice, stating that provided SSP payments stopped, then the employee can be furloughed. While it was still the message that furlough was not an alternative to shorter-term absences, the message seemed to be, provided they come off sick leave, then furlough can start. This is now slightly at odds with the Treasury direction, which states that where there is an entitlement to SSP, whether or not that entitlement is actually claimed, furlough cannot start until that entitlement ends. So for longer term absences, this could be a significant amount of time. And for shorter term absences, in particular when you're looking at isolation in the 14-day period, you're looking at a couple of weeks before furlough could start. This is more consistent with the earlier version, but isn't necessarily what everyone's been doing. So at this time, the safer position would be to wait until sick leave expires before furlough starts. But there are rumours of judicial review circulating for those parts of the Treasury direction that are in direct conflict with the guidance which businesses have been relying on. So the situation is less complex for employees that become sick while on furlough, however. So in this instance, the entitlement to SSP can ultimately be disregarded and the furlough can be maintained. So sick still has a couple of question marks over it, but hopefully that will be clarified through more of the applications made. So moving on to maternity and paternity, I've used them as an example, but it relates to all other types of statutory leave. So employees on furlough are still entitled to all family-related statutory leave in the normal way. Plus the calculation for the statutory entitlement to pay during that leave is based on normal wage, so that's pre-furlough and not the 80%. Now my view is that if statutory leave starts after the furlough period commences, it does not break furlough. The reason I think this is that HMRC's scheme allows employers to claim for enhanced earnings relating to that contractual maternity or paternity pay if it's within the contract. So if they can do this, then the employee on that statutory leave is also technically on furlough and the HMRC scheme remains open to the employer. So while on statutory leave, my view is that maternity and paternity leave takes precedence, but ultimately the furlough continues to run in the background and the employee would return to furlough with its related payments at the end of the period of that statutory leave. However, only when it comes to an end, that period of statutory leave. So while maternity leave, depending on when it started, will usually last longer than any period of furlough, the employee could still give notice to return to work or curtail their maternity leave and opt in for shared parental leave and be a bit more flexible as to whether they're on their statutory leave and in receipt of statutory payments or on a period of furlough benefiting from that 80%. I think the situation is different, however, if the statutory leave started first, so more for maternity, I think. So to benefit from the 80% of furlough, the employee would need to relinquish the statutory leave, curtail their notice and be placed on furlough. And as I've said, there is a potential to be flexible with your shared parental leave, which gives you the opportunity to pick certain periods of time of which you want to take as that statutory leave. And you could basically almost jump in and out of furlough and shared parental leave depending on what you've agreed with your employee. It can be a little complex, but I think it would be an option. Keith, do you have any comments on that?
No, I think that's a really thorough answer. I think the only one area that you really have to be careful with is maternity leave, because maternity leave is a special form of leave that you can't jump in and out of, in a sense, and once you've started it, you have to see it through, so to speak, which is why people have to front load and back load the holidays. So other than that, I didn't have anything else to add. I think then that sort of passes me over to the second question in dealing with holiday during furlough. This is a huge topic, and I'm trying to boil it down into 5 minutes, which is a bit of a challenge because I could probably talk on this all day. We've had loads of questions on it. The questions have gone along the lines of, does an employer have to hold over holidays for the next 2 years, given the amendments to the working time regulations? Can an employee take holiday, and does an employer then have to pay 100% of normal pay rather than the 80% on furlough? And can you force employees to take holiday during furlough? So I think what I'll do is just do a quick potted summary, which will touch on those areas really. The short answer really is, when dealing with anything on accrued holiday leave, you've got to break your holiday up into various chunks. Because different rules apply to different chunks. So, for example, you have the holiday under the Working Time Directive, which is 20 days per annum, inclusive of bank holidays. You then have a second chunk, which is granted under the Working Time Regulations, which tops up the directive holiday to 28 days per annum, inclusive of bank holidays, and different rules apply to that because it's granted under UK legislation, not under the directive. You then have holiday over and above both the Working Time Directive leave, Working Time Directive leave and the Working Time Regulations leave, which is controlled by the contract. So, in short, do employees still accrue holidays during furlough? Yes, they do. That is subject to, because it's statutory leave, they're still employees, they still accrue all of the holidays under the directive and under the working time regulations, so 28 days per annum, inclusive of bank holidays. You can disapply contractual holidays above that if you agree it in your, or if you have agreed it in your furlough agreement with your employees. Given the amendments to the regulations, do you have to hold over holidays for the next 2 years? I.e., can employees exercise a right to carry those holidays forward? Well, the answer, in my view, is no. Any holiday is subject to your operational requirements, and the regulations state that an employer can extend those holidays across the next 2 years. So where it has not been reasonably practical to take those holidays during the current year due to coronavirus. Now, I appreciate we are in lockdown at the moment, but what we have said, or what the government has said, is that people can leave the house, they can go for exercise, and so I don't see that anyone is being prevented from taking their working time directive and their working time regulations leave, because they can still get rest and relaxation. Okay, can employees take holiday? Well, yes, they have. They've said that the government has said that employees can take holiday during furlough leave. There's a bit of a conflict again between the guidance, which says yes, and the directive that was issued to HMRC by the Treasury, which doesn't say anything about holiday. However, it's going to be very difficult for the government to backpedal on it when they've said you can do it. You clearly will have to top up people's pay to 100% and make sure you knock off the days they've taken from their accrual. Can you force employees to take holiday during furlough leave? Well, again, my answer is yes. But again, you've got to break it up into various bits of leave. Under the Working Time Directive, you can compel employees to take holiday. You have to give double the amount of notice as the period of leave. So, for example, if you're going to compel somebody to take 5 days holiday, you have to give them 10 working days notice. But again, it's the rules, not under furlough, but the rules under the Working Time Regulations that apply. And that would apply only to the first 28 days given under the Working Time Regulations. So long as you give the various notice, you can compel people to take leave. But remember, at the same time, you don't have to do that, because if you want to save cash, you can also sit back and say, well, actually, there's going to be no holiday during furlough leave, and that too, in my view, is fine. Just remember, the taking of holiday during furlough leave and afterwards really is an employer's discretion as to your operational requirements, and you will have powers in the contract to manage things. Just one last point. If you're compelling employees to take leave, if you're going to do it for all of their holiday, for example, that above 28 days per annum, you're going to need power in the contract to do that. So again, slightly different rules for slightly different things. Ailsa, I think I've covered everything, but if there's anything you want to lump in and chip in with, please feel free to do so.
It's probably just a couple of points, Keith. It's really just my view is that ACAS have been quite clear on where they stand in the taking of holiday, which is that it can be done and that you can rely on that statutory notice period to ask people to take or to compel people to take holidays during the time. They're generally quite risk averse, so I think if the Treasury direction were to go in any way against that, I think it would be quite surprising. But again, I suppose it's a watch this space. And the other, if you were going to compel employees to take leave, be mindful about employees that have other childcare responsibilities, and they sometimes might save those childcare holidays. Sorry, they might save their holidays for later in the year, maybe through the school holidays, so that they have sufficient so that they can still meet any childcare requirements that they have. So to not give that any thought, especially if it's specifically asked, could put you in the realms of any potential sex discrimination angle. So it's probably just one to watch really if anything comes back. So I'll jump straight on to question 3, which relates to 0-hour or casual workers. So those with no guaranteed minimum number of hours. So it's always been the intention of the HMR scheme to cover casual workers. So while this type of worker doesn't have the same level of employment rights or guarantee of work, it appears from earlier drafts of the guidance that the calculation of an average working week was possible and could be used to assist those on a more casual arrangement. Employers are not obliged to do this, but many may wish to retain those bank workers that give them the flexibility that their business requires when things come back to normal. So there are 2 ways to do this calculation: an average daily or weekly wage using the last tax year, or a like-for-like payment looking at the same month or week in the previous year. So for seasonal workers, the like-for-like option is likely to be the better choice, subject to the time of the year that you use those workers. If the time of year is usually now, then that's quids in for the workers. If it's a Christmas period you'd normally use, however, it might not be the most beneficial option for them. New guidance was released yesterday, so giving some good and clear examples of the way to calculate normal wages, so it's worth having a read when you're doing your calculations. So something that you might not have factored into furloughing your casual staff is that a holiday liability is attached to furlough. So as Keith just said, the 5.6 weeks continues to accrue during any period of furlough leave. So by recognising an average number of hours or days of work per week per month for your calculation means that you must also recognise the holiday accrual for those identified hours or days. So this is a liability that many employers might not have actually factored into their decision. It's also one that can't be claimed back from HMRC at a later time unless, as Keith talked about in his earlier question, the worker uses those holidays during the furlough period and they are topped up to what their normal wage would have looked like during that time rather than the 80%. A question mark has been raised over the Treasury directions, which states payments which are conditional upon any matter are not taken into account for the purposes of the reclaiming furlough payments, as all payments made to zero-hour workers are likely to rely on them being offered and accepting work, so the employer making that offer and the employee or the worker accepting that work. It's arguable that that's a condition and that recovery might actually not be possible in respect of those workers. That to me though would be a completely strange and at odds outcome if given what the scheme's intended to do, and I think everyone's very much been focused on the spirit of the scheme, that it covers everyone and gives all workers, regardless of their status of, I suppose, number of hours, the flexibility to actually make those claims. So that's my view on it, and hopefully that answers that question. So Keith, do you have any comments on that one?
No, I think there's again a very thorough answer. As you well know, if there's anything on 0 hours workers, I go running down the office and ask you anyway. So you're better place to deal with it than me.
Good to know.
So it brings us briefly, I suppose, onto redundancy. Now, we've had a number of questions on furlough and redundancy. I'm going to very briefly deal with those, but what I would say is we are running a full online seminar on the 21st of May 2020, dealing with furlough leave, the removal of restrictions, and we will touch on the potential for redundancy at that point in time, both mass redundancy and individual redundancy, because I think it is inevitable that businesses will be operating on limited cash once restrictions are lifted and we all try and get back to normal, and some form of restructuring is going to be inevitable in the future. We will clearly be pushing out details of that, so please all look out for it. And if you can't see it, contact myself, Ailsa or David, who will be only too happy to sign you up. But looking at the questions we've had, when we reopen, if we do so on a phased basis, do we need criteria for returners? Well, in many respects, the people you bring back from furlough is in an employer's discretion. You're exercising a discretion who you bring back, because as it stands at the moment, you've all agreed for people to go away on furlough. When you're lifting that, it's down to the employer. Clearly, you're going to want to get your best people back as soon as possible, because they're your most efficient people, and you're going to want to be operating as efficiently as possible. The one thing I would say is that it would the only really area that you're majorly at risk in exercise of any discretion is discrimination. OK, so I think you should have some objective means of determining who you have brought back and why. Do I think that needs to be something as complex as a redundancy selection matrix? No, I don't. But you need to have some way of determining who's coming back and who's not that's non-discriminatory. And it would be better to have a record of how you've got that, whether it's in a spreadsheet or a generalised policy. If we are, what is our exposure if we don't bring employees back from furlough is another question. I.e. they remain on furlough, then you dismiss them as redundant. Well, I don't think there's any further exposure in my view. The government brought out an updated version of the guidance last night, which said that it will not break the furlough scheme for people to act as employee representatives or non-union or non-union representatives during the furlough period. So they clearly anticipate that there's going to be consultation on redundancy in the next few months, and they've said that people can act as reps and it won't break their furlough. They don't go as far as saying if you then consult with the workforce, does that break each individual employee's period of furlough? However, it stands to reason that if they have gone out and said for employee reps. You can act as reps during furlough. It's self-evident that you've got to be consulting with the workforce, and those reps are going to actually be seeking views of the people that they represent. And so that will not break furlough. What the spirit of furlough seems to be that an employee remains on furlough if they're not providing services to the employer and they are not contributing economically to the business. And as a consequence, so long as you are meeting that, it seems to me that consultation with union reps and with individuals must be able to take place during furlough. Therefore, by implication, the last question was, well, can we collectively consult during furlough? Well, I think, yes, you can, and the government confirmed that last night. I think with any internal procedure, be that disciplinary or grievance, so long as the employees are not providing service, I think you can crack on with that during the period of furlough leave. It would be mad if you couldn't, i.e. that somebody committed a disciplinary offence prior to furlough and you have to postpone that. That would be unfair and probably be seen as an unfair dismissal if a dismissal resulted at the end of furlough, so to speak. So normal redundancy procedures apply. Get on with them if you have to during furlough. Fingers crossed, people will be able to manage their cash and redundancies will be kept to a minimum. But as I see it, I think redundancies are an inevitability given the slowdown and the economic position that will exist as we come out. Ailsa, don't know if you have any final thoughts on that.
No, I think you've pretty much covered it. I think it's sad that it might be an inevitability, but hopefully our seminar in a few weeks' time will give you some insights and maybe some alternatives, but just get you more comfortable with the decisions that you're going to have to make later down the line. So we'll look forward to seeing you there.
I think that just leaves to David to wrap up.
Thanks very much, Keith and Ailsa. Just so you're aware, the firm is working extra hard to produce and deliver useful and relevant content, articles, blogs, podcasts and videos, all of which can be found on our website at www.sintons.co.uk should you wish to take a look. And you can also follow the employment team on Twitter at SintonsHR should you wish to. If you would like to discuss anything the team have raised today further, if you have any other employment related inquiry or any other legal inquiry, please don't hesitate to get in touch. And I've just popped the details of our speakers today on the screen. As I mentioned, we're going to be bringing these sessions to you each Friday at 10 AM until the end of May, and I'll send the link round to the next one in the next couple of days. And thanks for so many people signing up and actually physically viewing this now. That's brilliant. Next Friday is a bank holiday, so we plan to record on Thursday the 7th, still at 10 AM, just for that week only. So from me, from Keith, from Ailsa, thank you very much for listening this morning. We look forward to speaking to you next week. Thanks once again for tuning in, and just stay safe, everyone. Thank you.
Thanks. Goodbye.
Thanks. Goodbye.